You're watching The Legal Breakdown. So, Glenn, we touched on a really interesting topic in our last episode that I want to expand upon a bit here. So, let's say that the Supreme Court's immunity ruling impacts all of Donald Trump's ongoing prosecutions in D.C., Florida, Georgia, and New York. I want to talk about whether Trump could still be prosecuted if some of the issues presented by the immunity ruling are fixed, if they're remedied. So, I want to start with Florida here, and this is the issue that we talked about in the last video, but let's reiterate. Clarence Thomas dropped a little Easter egg, an advisory opinion in his immunity opinion, suggesting that special counsels are unconstitutional, which is, of course, the issue that Trump's attorneys raised in their latest motion to dismiss. How could that be remedied if, for example, the court finds that, yes, indeed, special counsels are unconstitutional?
Yeah, and not just an Easter egg, Brian. It's like Clarence Thomas sent the Easter bunny down into Judge Cannon's chambers and said, just dismiss the damn case. I've got your back. Okay, that concludes the comedy portion of my comments. Look, all hope is not lost. That is the top line message I want to send to everybody. All hope is not lost. Cases will be prosecuted, provided Donald Trump doesn't get reelected, because then, in my estimation, no cases will be prosecuted. But okay, so let's take a look at what the Supreme Court did and what the implications are down in Florida. First of all, Clarence Thomas said, you know what, Judge Cannon, I'm not so sure special counsel Jack Smith was lawfully appointed. Here is, I don't want to bury the lead. He was. Special counsel and independent counsel, laws, statutes, and regulations have been used in the United States in the criminal justice system since the 1800s. Courts, one after another, have ruled on the legality of those laws and procedures, and they have always been upheld, including Bob Mueller's appointment as special counsel. So Jack Smith's appointment as special counsel, absolutely lawful and constitutional. But what happens if Judge Cannon rules that, you know what, I'm going to go with Justice Thomas's suggestion and just say Jack Smith was not legally appointed, therefore he can't prosecute this case? Couple of things will happen. First and foremost, Jack Smith will appeal. Then the 11th Circuit Court of Appeals, which sits atop Judge Cannon and has reversed her before for abusing her discretion in Donald Trump's favor, will reverse her. But then, of course, Donald Trump will appeal it to where? The United States Supreme Court. And Brian, I can no longer predict, and I think it's a fool's errand to even try, what the Supreme Court will do with any case that has Donald Trump in the caption, United States of America versus Donald Trump. What they should do is say, like every other court in the land that has addressed this, Jack Smith's appointment was lawful and constitutional. Will they? I just don't know. So that's one thing. It will go all the way up the appellate chain to the Supreme Court, and they will ultimately have to decide. But you know what? There's always some silver lining, because I believe both Jack Smith and the Department of Justice, for all my beating up on the Department of Justice, I still believe that they are in it for the long game. And I do believe we're going to be talking about Donald Trump prosecutions for years to come. So let's assume the Supreme Court said, you know what? We're going to side with Judge Cannon over all of the other judges who have decided this issue, and say Jack Smith was not lawfully appointed. Then the Department of Justice steps back, and then they put a new team of prosecutors who are not designated as special counsel on the case, and they pick up where they left off. Because even though I promise you Donald Trump will argue in the event Jack Smith's appointment is deemed illegal, he'll argue that every investigative step Jack Smith took has to be undone, thrown out, ignored, and the Department of Justice has to start from jump. That will not be the case. Instead, new prosecutors will pick up right where Jack Smith left off, and they will continue to move forward in the Florida criminal prosecution against Donald Trump. All of that is my best guess, having lived in the Department of Justice for decades as a career federal prosecutor.
Okay, so that's one very acceptable remedy here in the catastrophic event that Judge Cannon and the Supreme Court rule that a special counsel is unconstitutional. The other issue in Florida is that Trump will say that merely taking a document which of course is illegal, is somehow an official act, which would, be an insane position. But if a court finds that he is correct and agrees with this insane position, then what is the remedy to that?
Now we are back on the appellate track. If Judge Cannon rules that Donald Trump's stealing, we're going to call it what it is, because when you take the property that belongs to another without the legal right to take that property, it's theft, it's larceny, it can be called a number of different things. Donald Trump stole those documents from the government. They weren't his diaries, which might, give him some play under the PRA, the Presidential Records Act. The president can take his diaries, but all records belong to the federal government, and a president can't take them. But if Judge Cannon says, you know what, I am deciding these were official acts, all of the documents he stole from the federal government when he left the presidency. Again, Jack Smith would appeal, and in a normal world, when we're not living in the legal upside down, ultimately the 11th Circuit would overrule and overturn Judge Cannon yet again and remand it back to her with instructions that, no, Judge, you're wrong again, and these were not official acts when Donald Trump stole these classified documents. Then, as we already discussed, Donald Trump would beat feet to the Supreme Court, and it's always anybody's guess. But if they ever choose to be honest brokers of the law, they will say that, no, stealing things from the federal government, even when a president does it, is not an official act that enjoys absolute or presumptive presidential immunity. So that's what would happen. But let's take it one step further. Let's assume the Supreme Court says, yep, stealing classified documents and military attack plans on foreign countries represents an official act of the presidency. A president gets to do it. Fine. Then what happens is the other criminal charges in the case moving forward, like obstructing justice for defying a grand jury subpoena, which is a court order requiring the return of those classified documents, while you're a private citizen, because Donald Trump had left the presidency by the time he received that subpoena, there's no way that could be an official presidential act that enjoys any level of immunity. So all hope is not lost, because even in the worst case scenario, where Judge Cannon gets it wrong to try to help Donald Trump, the Supreme Court gets it wrong to try to help Donald Trump, there are still remaining criminal charges that will proceed to trial. So that is why we all have to hang in there.
Okay, so that's two bits of good news in what would be very catastrophic situations in this classified documents case down in Florida. Let's move over to New York, because, obviously the immunity ruling has pushed back sentencing a couple of months. So in New York, the issue is that even though Donald Trump's falsification of business records was during his time as a candidate, that is why he falsified business records to hide a hush money payout, because he thought that the affair would hurt him in the upcoming election, he did sign reimbursement checks from the White House. So Donald Trump is going to say that it's an official act just by virtue of the fact that it occurred in the White House. And that's obviously flatly false, but it'll be up to the court's discretion, including the Supreme Court, to determine whether or not that's true. So what is the remedy here if let's just skip the initial steps and jump to the Supreme Court and say the Supreme Court were to decide that the reimbursement checks, for example, are inadmissible?
Yeah, if you'll indulge me, I will skip forward because I don't want to repeat what we've already talked about. But let me tell you, there is no rational view of the world, I believe, even in the Supreme Court, that will result in reimbursement checks, reimbursing Michael Cohen for paying off the porn star to help Donald Trump cheat in the 2016 presidential election. Even beyond stealing classified documents, no way, no way. Even the Supreme Court, in my opinion, I'm going on that fool's errand now, no way they will hold that was an official presidential act and enjoys immunity. But now let's go right to your...
You got Clarence Thomas waiting in the wings here going, you sure? You sure? Like, try me,
Hold my beer,
Hold my
Clarence
beer,
says.
exactly, yeah.
But let's go to the end game. Let's assume that the Supreme Court says, yep, reimbursing your fixer for paying off a porn star to try to cheat in a presidential election all enjoys presidential immunity. Why? Because at the moment you were signing the checks, you were now, sworn in as president of the United States. Insane even hearing myself say it. But let's assume that's what the Supreme Court says. Here's the good news. Always a little bit of silver lining. We're not being Pollyanna here. There's a doctrine in the appellate law called harmless error. What does that mean? There was a mountain of evidence against Donald Trump in the New York prosecution from David Pecker and Stormy Daniels and Hope Hicks and so many others. There were falsified records. There were phone records and messages. There was testimony of Michael Cohen. There was an undercover recording of Donald Trump basically saying, we're going to do this dirty criminal thing when he was talking with Michael Cohen. A mountain of evidence. The reason I recite all that, Brian, is because in virtually every trial, and I can say this for every case I prosecuted in 30 years, mistakes are made. There are mistakes made in every criminal trial because the system is populated by human beings and we're all fallible. So anytime there's a conviction that gets appealed, the appellate courts will look to the doctrine of harmless error. What does that mean? It means they look at all of the mistakes that were conducted during the course of the trial and they will decide, were those harmless errors or were they prejudicial and did they result in a conviction when, if the errors had not been committed, the defendant would have been found not guilty? I'm taking some liberties with the test just to sort of illustrate the point. Writing reimbursement checks at the very end of this long conspiracy that he was in with Michael Cohen is, if it's an error based on this new Supreme Court opinion that a president is king, it's harmless. It's harmless because there's a mountain of evidence that otherwise supports the conviction of Donald Trump in the New York case. So that's where the silver lining comes in.
Right, that makes total sense. And now let's finally bunch D.C. and Georgia together because they both concern undermining the 2020 election. So the situation here is a little different because we're in the pretrial period. So can you talk about what will happen if certain evidence or certain charges are found to be improper based on the immunity ruling?
Yeah, Brian, I think in some ways the news is even better when we talk about the Georgia prosecution and the D.C. prosecution because they are both in pre-trial status. There has not been a trial yet, and they both have honest judges, fair, impartial, independent judges, Judge Tanya Chutkan in D.C., Judge Scott McAfee down in Georgia. So here's what will happen in those cases. They will look at the Supreme Court ruling and they will litigate pre-trial the issues that the Supreme Court ruling has now dropped in their lap, whether the evidence should be admitted against Donald Trump because it was either an official act that does not enjoy presumptive immunity or it was an unofficial act. And there's going to be a mixture of official acts, but Jack Smith will be able to or Fani Willis will be able to overcome the presumption of immunity beyond the scope of today's legal breakdown discussion, or they'll just be deemed unofficial acts because he was basically like a candidate trying to retain the office of the presidency after he lost. So I think there's really reason to be optimistic that criminal charges will absolutely survive in both D.C. and in Georgia and will go to trial, provided Donald Trump is not elected, notwithstanding this Supreme Court ruling, because those courts and those judges have every opportunity to sort it all out in a pretrial status before the trial begins.
Look, I think all of this is especially important to go over because I feel like the overarching feeling right now is just that of despair, of hopelessness, of this sense that Donald Trump yet again got away with it. And I think as we're seeing right now, even in the most catastrophic circumstances where this immunity ruling really ultimately redounds to Trump's benefit in the biggest way, there is still a ton of legal exposure that he's facing, and all is not lost in any of these cases. So, of course, Glenn and I will continue to cover all of this as each of these cases continues to make its way through the justice system, and hopefully we'll see these out to the point where Donald Trump does face accountability for all of them. With that said, for those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.